Okay, good afternoon, everyone. Thank you for your patience. We're having some technical difficulties, but we sorted through them. Welcome to Division One's very first Toolbox Talk of 2025. Today we have a program that's being presented in partnership with Division 12. Thank you to Jason Cagle, who is the chair of Division 12, for helping us organize this. We have three presenters: Creighton Sebra of Clark Hill in Los Angeles, I believe; Angus McFadden from Atlanta, Georgia of Blueprint Construction; and Laurie Choi of Snell, Wilmer. All three are members of Division 12 and will be talking on the subject of selecting the right in quotation marks, dispute resolution procedure from the owner's perspective, where they'll be talking about whether parties should consider waiving jury trials. And looking at our speaker bios, I did want to note a few things. First of all, Angus McFadden is with the law firm Blueprint Construction Counsel, LLP. He is a 25-year construction lawyer who has worked on construction projects all throughout the United States, in addition to around the world. He serves as both an advocate and a neutral. So he is registered as a mediator with the Georgia Office of Dispute Resolution and is also a construction and commercial arbitration panelist with the AAA. Laurie Choi is a partner with Snell Wilmer, a full-service law firm in both the United States and Mexico. She is licensed to practice in Colorado and California, focuses on construction law and litigation. She, like Mr. Sebra, both have hands-on experience within the construction industry. She holds her general contractor's license and handles all aspects of construction law and litigation. Finally, Mr. Sebra has worked prior to practicing as a civil engineer, contractor, and commercial building contractor, where he performed both project management and project estimating roles. One of the highlights of Creighton's experience is that he obtained a jury verdict involving a public works construction dispute. So very relevant to our discussion today as to whether parties should consider accepting a jury trial or not. So with that, I'm going to turn it over to our panelists. I believe they'll have some information to share. If you've signed up to attend today, we'll make sure to circulate it after the presentation. The idea of this presentation is for it to be somewhat informal. I believe our speakers have some prepared remarks, but we will have a time for questions and discussion at the end. So I would say that if you have questions that come up, please take note of them, and we'll have some time for that as we get to the end of the presentation. So I'll turn it over to Angus, Laurie, and Creighton. Thank you.
Thanks, Brett. As far as we're concerned, if y'all have questions, I don't know if there's a way to raise your hand or just weigh in, take yourself off mute, and we're happy to answer as we go along. Thanks for that introduction, Brett. I guess we don't need to do those. About the topic, so if you're in litigation, once you get to a dispute, you're stuck with whatever's in the contract. What we're going to talk about today is what to put in the contract if you end up in a position to do so. I've represented owners a lot over the years, and a fair amount of my work has been transactional, upfront, putting the contract together kinds of projects. And the question comes up: what dispute resolution mechanism process do we want to agree to? Are we going to start with mandatory mediation? Are we going to do arbitration? Are we going to litigation? If we go to litigation, are we going to have a jury trial, or are we going to have a jury trial waiver? If we go to arbitration, if we have time today, we can talk a little bit about, what's the best way for selecting arbitrators, how many arbitrators, those kinds of things. But we'll start with sort of the pros and cons of arbitration versus litigation. And I don't want to do all the talking. So Creighton or Laurie, y'all want to jump in?
Yes, just one thing, in full disclosure, like Angus, sort of new development, I'm also on the AAA arbitrators panel. So hopefully I'll give an unbiased opinion today on my real thoughts on this, but in full disclosure.
Yeah, I, unlike the two esteemed other panelists, I am not on the arbitration panel. But yes, I guess. It is a very interesting topic in terms of how things have kind of changed with arbitration. I think 15 years ago, everyone would have said, definitely, in construction litigation, you want an arbitration provision, and that's, the way to go. And that may not have necessarily overall changed, but there have been some, some changes within, how the arbitration is administered and how, things are kind of going. And so we're not going to go over like any of the arbitration, provisions and things like that. Obviously, the AIA and consensus documents and other, forms that are used, provide adequate, language in that regard. I will say this, and I think everyone, the other panelists agree, that any arbitration provision should be coupled with a mediation provision, in my opinion. I think, because you can always waive that the parties if you don't want to necessarily go to mediation. So I think that's very effective prior to actually going to arbitration or litigation, whatever your mechanism is, that you have a mediation provision in that regard.
So we can dive
ahead,
into
Laurie.
the pros and cons about, when you're weighing all these options. I think we had some consensus among the group as to it being, not a clear preference, every single time for every single project for every single client. I think that we sort of all agreed that it, in large part, we defer to client preferences. If somebody's had a bad experience with one or the other in recent history, we can work through, and I think that we'd suggest going with what the client wants to do. But, when the client's not sure, if the client wants to talk through, weighing their options, like we have some pros and cons that we've put together in terms of that. So just to sort of kick that off, the biggest reason I see from clients on why they're preferring arbitration when they do is for the privacy aspect of it. Having a confidential proceeding, not having all of the pleadings out there for public searches and things like that. I've encountered that a lot with like home builder clients or other larger companies that have consumers who are, single family homeowners or things like that. So that's one of the things that we wanted to mention in terms of a pro for arbitration.
Yeah, that's very, very well said. That's something that you can't, obviously get in the litigation. And so to be able to keep those proceedings confidential is very important to, particularly a lot of, owner clients. In my opinion, the greatest with selecting an arbitration provision is the flexibility that comes with that. So you have flexibility with respect to, how you're going to administer, the arbitration itself. The scope of the arbitration, can obviously be limited. Pre-arbitration motions or things, as well as any discovery. And so that flexibility really allows the practitioners who are handling the case to fashion the matter pinpoint, and that certainly helps keep the cost down and other things like that. So that's really one of the benefits, confidential and the flexibility. Downside, one of those things with Laurie mentioned, the confidentiality. If you're on the other side of winning that arbitration award, you will have to enforce that judgment. So part of it will eventually become public record if it has to go through the enforcement proceedings. But I'll let Angus give his input as to his key points on what he thinks the pros are on arbitration.
Yeah, thank you. So building on something you were just saying about flexibility, one of the things from the owner's perspective, depending on how well the contract is written and administered, can be in a real information vacuum on a project. And so, I mean, the contractor and the subcontractors know a whole lot more about what's going on in the project, probably, certainly behind the scenes in terms of scheduling and costs and things like that, than the owner does. And so the owner is going to need, if they get into a dispute, they're going to need some discovery. And in litigation, obviously, there's no question that almost every court's civil rules of procedure are going to give you plenty of opportunity to get discovery. Arbitration discovery has become much more common, but there is currently a push to make arbitration more efficient and to have less discovery. And there are prominent members within the ABA who will say, if they're the arbitrator, they won't allow depositions except in really extreme circumstances. And so, that is one thing to consider when you're drafting an arbitration provision. If you're from the owner's perspective, is make sure that you as the owner have the opportunity to get all the information that you need relevant to the dispute, if you get to that point. Whether that's built into the contract along the way, but then you have to enforce it, or as part of the discovery process in arbitration. Also, from the owner's perspective, I had one of the first partners I ever worked for when I was a young associate was really opposed to arbitration because he thought arbitrators were biased. He thought arbitrators mostly came from one side of the coin in the construction dispute world, and he wasn't on that side of the coin. And so it's something to be aware of, something to be on the lookout for. And I think that goes into, if you're going to choose arbitration, what you say in your provision about who your arbitrators are and how they're selected, especially if it's a big dispute. Go ahead, Laurie.
Oh, I was just going to mention to that end, like the flip side of that is that there's an expectation that if you are having an arbitration clause, that the parties may be able to choose somebody who's the fact finder who has experience in construction, right? And doesn't need to learn about the complex procedures and other technical aspects of what may be in dispute.
Yeah,
Yeah.
absolutely. We tried a huge case in the Southern District of New York, and the foreperson of the jury was a bus driver. So it's not anything against bus drivers, but they don't have a whole lot of knowledge coming into the game about construction projects.
Hopefully no one's a bus driver on this in the Zoom.
I'm not
kidding.
disparaging bus drivers. I'm just saying she didn't have an engineering background, nor did she have any sort of law degree or experience with construction projects.
And that's definitely one of the balances here. I've tried a number of construction jury trials. In my experience, jurors like to pick winners or losers, and they like to see who's the bad actor or who they feel was at fault. And so you tend to get an all or nothing type of thing, whereas arbitrators are more skilled at looking at the overall aspect of this and seeing that in most construction disputes, it's usually not one person's right and one person's wrong. There's varying degrees of culpability, and so the arbitrator can usually fashion a solution that can work for all parties. Now, some people don't like that, splitting the baby, that sometimes isn't, preferable. But in the sense, and I agree with Laurie and Angus, and the fact that you do get to choose a neutral, whether, and everyone has bias. It's, obviously, Angus is mentioning that, sometimes, these arbitrators might have some, but every juror has a bias. They all have different, they bring their own walks of life. You just have to deal with that. But generally speaking, in my opinion, an arbitrator who's selected, from one of the national panels or locally, they try to put their biases aside. Generally, they're professional in that manner, and you can select a construction arbitrator, so they have that experience, and that really helps in terms of that you're not educating on the construction process. For example, if you were to use a term like CCD, right? A construction change directive. Construction arbitrator knows exactly what that means, whereas a juror may not. So there's a lot of education that has to go into if you're going down that litigation route, and you just have to really understand that and be prepared in that regard.
Yeah, and along those lines, litigation's certainly now, I think it's going to be slower, a lot slower in terms of getting to the hearing or the trial. It's probably going to have more expensive discovery. One of the flip sides, and again, something to think about, is depending on the court, you're more likely, or at least have a greater chance of getting a ruling on a dispositive motion if you've got a strong contractual argument, strong legal argument, whereas less likely, at least in my experience, in arbitration, because one of the bases for getting an arbitration award overturned is the failure of the arbitrator to hear evidence. And so that's, I think because of that, a ruling on a dispositive motion, certainly something that gets rid of the entire case, is less likely in arbitration than it is in litigation. Not necessarily a reason not to do it, but just something to be aware of.
I think that doesn't just apply to dispositive motions. And I've also had the same experience as Angus where I have tried and I've seen a lot of people try with dispositive motions in arbitration, and we sort of joke around as practitioners that it'll never happen. But I think in addition to that, there generally is, under the AAA rules anyways, it provides for really wide latitude and discretion by the arbitrator in letting in evidence. So I think that most arbitrators sort of err on the side of letting everything in, letting things go to the weight. And so, like Angus mentioned, whereas there may be opportunities for efficiency, perhaps some of those aren't really realized in arbitrations as in practice.
Yeah, I agree generally that, an arbitration is going to be faster, going to be a more efficient resolution of the dispute. As an example, I have a case in New York right now. It's in the town of Huntington, and we're going on 6 years. And we're just having our first meeting. I got to go to the mediation, next week. We're just having our first mediation, and part of that's been COVID and other things. But that's a long time for parties not to be able to get to the resolution process. And when you have a longer litigation, of course, the costs do go up with discovery and all those other things. Now, having said that, we did discuss between Angus and Laurie and I that arbitration costs have gone up over the years. And if you do have a 3-panel neutral, now you're talking about a significant cost of when you go there. And of course, usually you have to pay those costs up front before you actually proceed to that arbitration. So there can be a $150,000, sometimes even $200,000 deposit that is paid on significant arbitration before you actually hear that. Whereas you don't have that cost per se in litigation. Thoughts, Angus?
I think that's right. I just am looking at the clock. I wonder if we want to take 1 minute just to not make Brett have said we're going to do something we didn't do, and talk about jury trial waivers. Which I mean, I totally agree that there's more to be said on arbitration versus litigation, but I do think this is an area where I think depending on your experience and what good and bad experiences you've had, I think certainly a lot of big corporate clients are afraid of juries. But based on my experience, I'm afraid of some judges. So my personal view is, I'm very wary of jury trial waivers, because I think juries, more often than not, at least are trying to do the right thing, and they don't come into the matter with the same approach that a judge would. I'd got to be careful about how I say that, but not very many judges are construction lawyers either. And so, and they don't like big, long trials that clam up their docket. And anyway, so what do y'all think?
Well, I think having discussed this together, what really stuck out to me was, Angus made mention of sort of specific areas that make him nervous about the jury trial waiver. And I think that's really important to consider. What's the venue? If we're going to be in litigation, what's the venue of the litigation? What do we think about the judges there? And maybe you are better off with the jury. So again, I don't think there's a black and white, hard and fast answer for this every time. I think it depends on the client, depends on where you're located.
Yeah, I would agree with that. I'm loath to agree to jury waivers because of that, because you can always agree to go to litigation, something you really have to be careful with. Now, I do practice in California, and so I think people would tend to want to stay away from some of the California juries, and so that might be a better practice if you have a project in California that you may want to avoid that. And also, just what Angus was saying with respect to the judges, state court judges are really underfunded. They don't have the resources. Their docket is very burdened, and so having a judge trial in state court, I would definitely rather have a neutral or arbitration. In terms of the jury trial, I agree with Angus that the juries definitely try to do the right thing. It's just how long is it going to take you to get to that jury trial, and and what are the costs, and how long is that jury trial going to be, and can particularly what I've seen in California is that finding 12 jurors to sit for a 4 to 6 week trial is very, very difficult. My last trial I did, because of the lack of the jury pool, we had to agree just to have 8 jurors. And so that is a complication that you can't always foresee, but something that you should keep in the back of your mind as you're crafting these provisions.
Yep.
One thing that we didn't quite touch on with regard to just straight up arbitration versus litigation that I'm sort of experiencing now is where there's an arbitration provision in the owner GC contract. GC is required to flow it down, and it does to the subs. Then from there, nothing is flowed down. And due to issues on the project, there are now a bunch of lien claims, right? And so there's this question of, I had run down this question the other day, and basically where we shake out on this is that the arbitral claims have to be arbitrated, and we're going to stay the litigation, but then we'll have to readdress all the remaining lien claimant claims in that litigation later, since they never agreed to an arbitration agreement. And so, I think the intent, I'm sure at the time of contracting, was to have a really streamlined, efficient process. People decided we want arbitration, but here we are, and we're going to have to do both.
Yeah, the flow down provisions are definitely, can be an issue. And so that's a little bit of, care and feeding after you get the contract signed to ensure that. And that's, something you can, you can make a motion to bring in parties who have not agreed to an arbitration provision. And I've been successful in doing that. But arbitrators are a little loath to agree to that, particularly when there isn't an agreement by those parties. And so that's something to consider. Angus, any thoughts on that?
No, I totally agree. I mean, it's obviously from the owner's perspective, you're gonna have the dispute resolution provision that you want, and you're gonna tell the contractor that they have to flow it down. But to Laurie's point, getting it to the sub level and making sure it happens, that's a level of project management that might be beyond some, fair number of clients, either abilities or intent, what they want to do. And it's, I'm involved in something now where there's 2 arbitrations and 1 litigation in federal court all over the same project. And it's just the way that the contracts are written and the way that the joinders were done in the federal court. So it would not ideal by any stretch. So that's it's a drafting exercise, obviously, and it's an important one, but it's also a sort of contract management, contract enforcement exercise from the owner's perspective. I'm looking at the clock.
Yeah.
Do we want to give a second for questions?
Yeah, we're at 12:30, and I do appreciate. I think you all have taken a pretty fair and balanced approach in terms of walking us through the pros and cons of both arbitration and litigation. And then whether, if we're choosing litigation, if it's going to be a jury or non-jury trial. I would like to start with the panel and ask you all to tell me in 1 sentence or less what your preferred method of dispute resolution is and why, maybe 2 sentences, when you're representing the owner. And we'll start with Laurie.
Yeah, you're not going to like my answer. So my answer is I defer to the client, because typically clients have preferences.
Laurie punted. Good job, Laurie. I spoken like a true attorney. So in my opinion, I think it depends on the project. So kind of like Laurie, the value of the project is the key driving factor. And if it is a high value project, then I definitely would choose arbitration with the mediation provision. If it's a lower value, then I'm less concerned about the arbitrator, because I think the arbitration costs will outweigh going to litigation.
Yeah, I prefer arbitration for sure. I think that the value of the dispute will work itself out. If it's too small, and that'll just actually encourage the parties to settle. But I would do arbitration with a stepped. I would definitely modify the standard AAA rules in my clause. And I would do a stepped, one arbitrator if it's small enough, and 3 arbitrators if it's a big dispute. That'd be my preference.
Okay. I appreciate the succinct answers. What I'd like to do is open it up now to the folks that are on the line, because we have gotten the owner's perspective today. But if you're on the line and you represent a party typically other than the owner, whether it be the contractor, design professional, subcontractor, supplier, I'd be interested to know what your checklist is in determining which dispute resolution provision to select or that you prefer and why. And I do know a handful of people on here, so I may try to pick on somebody if nobody volunteers. I'm not afraid to do that. Sanjay, are you there?
I am.
Tell us about your perspective on dispute resolution provisions as a Florida lawyer that tends to represent the association.
Yeah, I don't, my view is all arbitrators hate condo associations. And therefore, and with the jury, a lot of jurors might hate condo associations, but not all of them. So generally we fight trying to go to arbitration. What I will say that I've had a few recently where the other lawyers actually came back on the developer side and said, look, if you guys will waive your jury claims, we'll happily go forward with the bench trial. And they just didn't want to be in front of a jury. I was happy to be in court because there's rules, and I do admire that Laurie got to avoid the question, because my clients, when I say, well, what do you want to do, say, well, what do you recommend that we do? and I always recommend we go to court. So that's just my 2 cents. Thank you. Thanks for calling me, Brett.
My pleasure. Thank you, Sanjay. Is Patricia still on the line?
Yes, I am.
Okay, I'd like to get your perspective on the difference between the AAA and JAMS and why parties should consider one versus the other.
Oh, listen, you are not going to get me to go there. They are fighting. There's little spats going on there, and I don't want to step in the middle of that. I think that their construction rules are very similar. So let me say that you should investigate yourself what the differences might be, because if I get quoted on this, I'm in trouble.
Okay.
But let me answer this. I used to represent sureties. I'm an arbitrator now with JAMS, but my career was representing mostly sureties. And in the beginning, I was told no way was a surety going to be in arbitration. Forget it. And then we realized, man, arbitrators can appreciate a surety a whole lot better than a jury and a judge. And so it is the more sophisticated the arbitrator, the more well-rounded the arbitrator's experience, the better they can appreciate the role of every single one of the parties and the limits on their respective liabilities.
Thank you, Patricia.
Welcome.
That actually does go to one thing that I've sort of observed with clients. And if they have a strong preference, it's usually based on their last bad experience. It's not necessarily based on their last good experience. It's based on their last bad experience. Like, where did they get killed? And they'll never want to do that again, whatever it was.
Not a very good statistical sample if you think about it.
Right.
It's very true.
All right. Well, we're shortly over our 30 minutes. I'll give it a few more moments before we end today's presentation. If anybody else has any other questions or comments, now would be your time.
Hey everybody, Matt Bouchard from Pointer Sproul down in Raleigh. Just a quick observation. Sometimes an owner might not have as much of a choice as they might otherwise want to have at the contracting stage with the prime contractor. If you've got a project delivery that's not design build and a design professional who refuses to arbitrate, it becomes a little bit risky to select arbitration with the prime contractor if there's a risk in the defect setting, the owner having to fight a battle with the contractor in arbitration, but if there's a possibility the design professional is responsible, fighting a separate battle in litigation. And so I've had situations for sure where, in giving the advice to the client, if they were already under contract with a design professional and that contract didn't include an arbitration clause, I'd be inclined to say either stick with litigation downstream or consider a unilateral arbitration clause.
That's a
Okay.
good observation. I agree. Consistency is very important.
Andrew, do you have something to add? Go ahead.
Hey, Brett, Andrew Vickner here in New Orleans. What is it with arbitrators not wanting to allow the parties to agree amongst themselves on what I would call procedural issues? And I can tell you, maybe I've just had a bad experience the last couple of times, but I will never recommend arbitration because I get the feeling that the arbitrator or somehow the case manager just arbitrarily wants to ignore what the parties have agreed to procedurally, and it just leaves a bad taste, not only in my mouth, but in my clients as well. I just don't know what it is, and this is primarily with the AAA. I have only used jams once. It just seems to be a recurring theme, and when I ask other attorneys, I kind of get a lot of the same feedback, and I just don't understand that.
Yeah, from I haven't had that same experience.
Patricia has something to add as an arbitrator.
Listen,
go ahead.
you should interview your arbitrators before you choose them and say, what is your philosophy? Isn't it the parties' process? If the parties will agree to this, is there a reason why you won't let us do it?
Yeah,
Yeah,
in
and
my
go ahead, Greg.
My experience has been that same thing. You know, like we have a number of meetings before we even are setting, you know, arbitration dates, and we're working with the arbitrator. Okay, what do we need? You know, do we need to have these procedural motions or what else? And it's some discovery, whatever the case may be. So I think communication early on with the arbitrator, I know that costs more money, is really key. And I haven't had the same experience. Generally speaking, most of the arbitrators are willing to work with the parties, especially if the parties are stipulating. Now, if there's a dispute, then yeah, the arbitrator doesn't really like to, you know, choose sides because he's going to be hearing the, you know, the tribunal. So, but if the parties are stipulating, I don't understand, you know, that the arbitrator would not be willing to do that.
Yeah, my understanding is sort of the same as Patricia described. It's the parties proceeding. So, I mean, that would seem unusual, and I've not had that experience. So maybe it's
Yeah.
like a regional thing.
Arbitration is a creation of contract. So if the parties are agreeing, they're effectively modifying their contract and agreeing to do something. So the arbitrator should not overrule that. Doesn't really have authority to overrule it, in my opinion. There is a lot of pressure to not have arbitration be as, you know, discovery intensive and as inefficient as litigation. And that may be what your arbitrators are dealing with, Andrew, that they're getting pressure somewhere to be, you know, to make the proceeding efficient. But certainly, I mean, my personal approach as an arbitrator would not be to force the parties to do something that other than what they've agreed. If they've agreed to do something, it doesn't seem like it would be the arbitrator's role to overrule that.
Okay. All right. Well, great conversation. Thanks for joining us. We have about 6 more of these for 2025, and we would invite you all to attend and participate. Thank you to Laurie, Creighton, and Angus, along with Jason for working with Division 1, and we look forward to seeing you in person at an upcoming meeting.
Thanks for having us.
Thank you,
Thanks,
everyone.
Brett.